Hi, welcome to The Truth About Estate Planning. I am Paul Grant. This is Danielle Olero and Richard Kalinsky. And together we are planning with purpose. So just want to take a moment to introduce ourselves. My name is Paul Grant, as I stated. I went to Central Washington University for my undergraduate and to Cooley Law School in Michigan to get both my law degree and my Master's of Taxation. For me personally, I've taken a little while to get to the area of law. I worked for UPS for almost a dozen years, and I worked as a preloader, worked as a driver up on Capitol Hill, but I'm not a very big guy, so that broke me down pretty good. Began to open up small businesses. Those took off, so I hired employees, was looking at contracts, I was flipping homes at the same time. And being in contracts all the time kind of gave me a different view of what it meant for law. So I took a basic Law 100 class at Edmonds Community College, and lo and behold, I found my calling. So within the next couple of months after that class, I re-enrolled in school, finished my 4-year degree, and then at the age of 38, moved my wife and 2 girls to Michigan so I could go to law school. So there's a little bit of my history. I've also been a basketball referee for quite a few years. Not doing it right now, but did a lot of high school ball, did women's collegiate ball, and also served on a nonprofit for the past 23 years as well. That is a little bit about me, and I will turn it over.
Hi, my name is Danielle Olero. I grew up over in Eastern Washington. My parents still live over in Tri-Cities. And I grew up riding horses and playing soccer. I went to Gonzaga University for my undergrad, got an economics degree, and then moved over here to Seattle to go to law school at University of Washington. I graduated in 2017 and then joined this firm in October of that same year. And so Paul and I and Richard are all part of the National Network of Estate Planning Attorneys as well. And that is where we get a lot of our business philosophy, and then our colleagues, those people who are members, are about 100 other estate planning attorneys throughout the United States. We get together 2 or 3 times a year, and we're able to talk with them. And so, so that's something that we all do together as well. So now I'll turn it over to Richard.
So my name is Richard. I was born in Belarus, and my family migrated to the United States when I was just 6 years old. Seattle has been home ever since, and we love it here. I graduated law school. My undergrad was in the University of Washington, where I took psychology, and I went to law school just a year after that. And so I graduated law school in 2018, and got in contact with Paul the year after that, so I've been with this firm since November of last year.
I'm so sorry. Well, today we want to talk to you about estate planning, so thanks for tuning in. And unfortunately, our premise is that most estate plans just don't work. So why are some of the reasons that estate plans don't work?
Well, a big reason that estate plans don't work is after a person comes in to get their estate done, very rarely, if ever, do these estate plans get updated. Now you can imagine why that could be a problem. Paul, if you look at the last 10 years of your life, has your life changed?
Quite a bit, yes.
Have your financial circumstances changed?
Fortunately, yes.
Good. Has your investment portfolio changed?
Right?
Yes. Family dynamics change,
Yeah.
Family changes, kids can be born, grandkids can be born, and unfortunately, if an estate plan doesn't reflect all of these changes, is it really as effective as it could be?
The answer is no then, right? Yeah, what other things could be changing?
So the law and the taxes are also things that are always moving.
Just always gone. Yep.
And most of the general public, not the 3 of us sitting in this room, aren't necessarily looking at all the laws and the taxes as they change. We're a little weird like that.
Yes, we are.
So that's another thing that's constantly changing, and again wearing down that effectiveness of that estate plan.
Yeah, and so we're going to uncover many other reasons through our short discussion here of why estate plans don't work, but don't worry, we're going to give you a lot of hope of how to correct that in your personal estate plan because we think we have a system that by relationship really does bring a different way to do estate planning.
Estate planning is very multifaceted. It doesn't just cover one aspect of your life. It covers many different aspects. So we came up with what we believe is a pretty simple definition of estate planning. Number one is, I want to control my property while I'm alive and well. Paul, do you like control?
According to my wife, yes.
He likes control.
Yes.
So you're telling me that the car that you own, the house that you own, your investment portfolio, you like to have control over it?
Yeah, it would be very nice if I could choose when I sell something or buy something.
Yeah. We like control, and that's perfectly fine. Number two, an estate plan is able to plan for myself and my loved ones if I become disabled. Now, when we say the disabled, we mean this could be something as simple as I can't manage my finances for one reason or another. It doesn't have to be something as extreme as incapacitation, although that very much also falls within the realm of disability.
Sure. Yeah.
And then the last part of our definition of estate planning is kind of what you more people think about when they look at estate planning, which is you want to give what you have to who you want, when you want to, and the way you want to after you've passed away. So we have 3 different stages, and so that's the last one that we want to address.
So the 3 different stages is that we want to plan for when we're alive and well. We want unlimited counseling. Want to make sure that your estate planner works collectively and cooperatively with any financial advisors, CPAs, and other professionals that you trust in your life. That way we get to the same conclusion together instead of independently making decisions that might not work collectively. Stage 2 is we want to make sure that we've planned for your disability, so not just that we have a document, because the document isn't going to save the day, but rather we've also taken the time to train your family, train those who are going to need to step in beside you and ensure that you are safe and your finances are being utilized as you have envisioned. And lastly, the 3rd stage is, yes, we want to plan for passing away. That's kind of what we think naturally with estate planning. So we want to make sure that the transition for your family is as smooth as possible. As a matter of fact, that is probably one of the highest, if not the highest goal that every client of ours has, which is, I want to make sure that
Right.
if it's time to go home, that I don't leave a mess to the ones that I love and they're scrambling around not knowing what to do. So we have to have a smooth transition. We can only do that through really good planning. And then, would you like it to be cost effective? So in other words, how does cost become out of control? Well, by paying attorneys, to be honest, correct? So in our relationship system, we have caps on what that means for you and your family. We want to make sure that not just a smooth transition, but that your finances and what you have left over get to the people, the charities, or whoever else you want, that it gets to them, and that we keep cost control in check.
Yeah, so like Paul was saying, the moving stuff and making sure that that things get to people in the proper way, that's the easy part for us. So our proposition to you is to make sure that the transition is easy for your beneficiaries and to educate your family. So estate planning isn't about the document. Like Paul was saying, the document's not the thing that's going to save the day. Estate planning is about people. And so our goal is to create predictable and known outcomes that you see in your head, that we can create something that we know what's going to happen, and it will be an easy transition with the education and the program that we have here.
Yeah, so that kind of brings us to the planning pyramid. And what we have found is that most estate plans actually have it reversed on its head. So unfortunately, many people use templated versions of estate planning documents. Unfortunately, some attorneys use templates. You can find templates online. You used to be able to find them at Office Depot and at paper stores. they're all over the place. So what the template does is that it deals with taxes and the law first. So because it's templated, it is forcing you to make decisions based upon a pre-designed set of laws. And it forces you and your family into the document instead of actually having the proper perspective of what we believe is the proper perspective of relationship. So we need to start any estate planning project with you as the foundation. What are your hopes? What are your dreams? If you were to pass away, what does that vision look like? What do you want to have happen? Not what do you hope, but like Danielle was saying, a predictable known outcome. What do you want to have happen? Then we need to understand who your family is. Who are the kids that are financially responsible? Which ones are having struggles? Do we have any children that have addiction issues that may in the future get away from them? So do we leave things to charities? Are they larger charities or small charities? How about grandkids? So the list goes on and on. We need to uncover in the family section who is receiving what, because understanding their strengths and weaknesses allow us to build a better plan to ensure that the wealth and the expansion of wealth are actually being distributed properly and utilized for as long as you envision it to be done. So then we're kind of at the last stage, which is really the taxes and the law. So during this time, right now, while we're filming this, you may be stuck at home. So has anyone done a jigsaw puzzle by chance? Well, if they have, what's the easiest piece to do? So what are the most common answers that we get? We ask this all the time. What's the easiest piece in a jigsaw puzzle to do?
Well, when you asked me the first time, I figured that maybe the corners would be the easiest.
Yeah, they're kind of square, right? So you can find squares.
And the edges.
And the edges, because they're the straight ones.
Yeah.
Yep.
Our proposition is that it's the last piece. You've only got one place to drop it, and you see the full picture. That's really what law and taxes should be. We should be utilizing the law and taxes to wrap around every single desire that you have, around your family, around your wealth, to accomplish exactly what you see and what you want your estate plan to do.
So there are several different ways that we can do estate planning. And there's really only one wrong way to do estate planning, and that's doing nothing. But you're watching this video, and so you're not in that boat.
We can
so
help
thank
you.
Yes.
Yeah, that's right.
So the next ones we'll talk more about what is a will. So a will is one way we can do estate planning. Joint ownership, so if you own an account with somebody else, that's another way that we can do estate planning. Or if you've signed beneficiary designations on those assets as well, that's a form of estate planning. Giving assets away, and that's not just necessarily to be generous, but for estate planning purposes. And then we'll also talk about what is a revocable living trust. So everyone needs one of those, at least a will or a trust, in order to have their estate plan completed. And then they also need a financial power of attorney, a healthcare power of attorney, and then an end-of-life document. And then we've got some other documents that sort of support those main ones. So we're going to talk more about those.
So you might have heard the term probate. You might be wondering, what is probate?
What is probate, Richard?
Great question, Paul.
Thank you.
Probate is a necessary court process for the estates of individuals who have passed away and they have property still in their personal name. So in other words, if I die and I had property in my name, my estate has to go to probate because I can no longer sign my name on the deed.
That's true.
Would you say that's pretty accurate?
Yep.
Yeah, and my whatever power of attorney I might have had also terminates at the date of my passing, so that no longer applies.
Yeah,
So what do we
every
do?
power of attorney ends as soon as someone dies. That's actually something that we hear a lot about. Well, I took the power of attorney to the bank, but they're no longer alive. It doesn't work. Or I took the will to the bank,
Yep.
and the bank goes, sorry, I can't look at the will. So unfortunately, these documents need to have somebody behind it, like what you're explaining,
That is
to
correct.
actually do the work
Right.
that is set out. So power of attorneys end at death.
And this is where the probate process comes in and provides a solution. Probate does two essential things. It authorizes someone to act on my stead if I have passed away. So it acts sort of like a power of attorney, that's the function. And number two, it gives that someone the authority and the power to collect all of my assets and pay off any debts that my estate has. Probate isn't perfect. By far, not perfect. It has what we believe are three big evils. The three big things that really make probate a difficulty is it takes too long. On average, probate takes 6 to 18 months to complete. It costs too much. In Washington State, it averages at about 2.5% of the total estate worth. And it's a fully public process. That means the names, addresses are all fully public and accessible by anyone, really. So, in short, we like to avoid probate, and we can avoid probate.
Yeah, so really, think of a will as a document that gives somebody cash. Very similar to a beneficiary designation, or a transfer on death is another term that people often use. So both of these systems do one major essential function. So the will does exactly what Richard was saying. Is number one, it names who your personal representative is. That's what we called in Washington. Other people, executor or exectrix or other names they're known by, but in Washington, personal representative. It empowers them, but then number two, it tells us where your money goes. So if we used a will, and these two guys were my beneficiaries. Okay, so that means that I had 2 Twixes in my lifetime. And I say, oh, let's have both of these beneficiaries receive what's in my will. So each of you, congratulations, get my portion of the
Thanks,
Twix.
Bob.
You're welcome. Now, the storyline is very diverse in them. So I really like Danielle. So she goes on to be very successful, and she actually does what we always hope, is that she invests her money well, she has a good life, she gets married, she has kids, and life is grand, and there's flowers and birds and butterflies all around her. However, Richard, poor Richard, his storyline, unfortunately, is that as soon as I gave him his money, he felt the compulsion to buy a very big truck with very big wheels. So then he went out and he utilized a lot of his inheritance. Now, why is he able to do that? They have different personalities and they have full control. In other words, if it's in their hands, it means it's theirs. Yep, that's what Richard would do, grab it. And so it's in their social security number, and these potential options could happen. So then the story goes on is that he takes that big truck, and he likes it, and he drives fast down the road, and he makes a driving error because he's also texting at the same time. Bad Richard. And he runs into somebody. So now, I should have given him multiple. So here, we'll give you equal amounts of stuff. So now he caused harm, okay? Because it's in his name, he's already spent some of it. Now the person that he caused harm to can come in and just say, you know what? Your insurance didn't cover me. I'm going to forcibly take this away from you, and now it's mine. Here's the other part of Richard's story. After that accident, his wife doesn't like him anymore. So now she wants to walk away from him. Well, he's holding a little extra money. Now, there is law that would say an inheritance is protected, but because we gave it to his hand, his wife is going to cause a problem. Actually, the attorneys are going to cause a problem. And they're going to start arguing over how much he used to support the community, whether it's his, whether it's theirs. And it becomes a huge mess, and he spends a bunch of money on attorney fees. And then after all this, he has to go through bankruptcy because of the accident, because he bought something with big tires, and because he went through a divorce. And now eventually, everything that Richard had is now gone. Now, I know that that's not a dreamy, rosy picture. And we hope, actually, with every client we meet, we hope that your kids are as responsible as what you believe them to be. statistically, we know something different. And unfortunately, what a will does is it simply gets it to the right person. So it did its job. It did fulfill its function. It named who's supposed to sign on your behalf as the personal representative, and it did get money to the right people. Just like a beneficiary designation. A beneficiary designation is a contract with a financial institution, and that financial institution must follow the contract even after your death. And that contract says, split my financial money to these two people, because they're named as the beneficiaries, so they simply get the cash again. And it puts it in their hands, and now that money is open to what I like to say, I hope life treats you well. If it doesn't, so sorry. So, with all that, a will is not that, it's not that a will is wrong. It is a tool that fulfills its function. It's just that the function is very narrow for a will. And like Richard was saying, we have to go through the probate process because we need a judge to empower somebody to sign on the deceased's behalf. We have to have a court approve that process. That's why it's mandated with a will that you go through probate. Now, there's ways to avoid that. We can do all beneficiary designations. That will avoid it. Nowadays, even a house you can put on a beneficiary designated asset. Or we can move kind of to the next discussion, which is we can utilize the power of a trust instead of a will, because these are the only two tools that we have. We can use a will or we can use a trust.
Yeah, so a trust is basically like this candy bowl. So as a trust maker, that would be whoever's creating the trust would create the rules around it, and that would become the container. And so this container would be the trust itself, and then all of your candy in life, so your bank account, your house, your investments, everything that you own would then be titled into the name of the trust. So for example, for me, instead of my bank account being under the name of Danielle Olero, now it's in the name of Danielle Olero Trust. Then my hand would go underneath the candy bowl, so I have full and absolute control and access to everything that's in here. It's actually still running under my social security number, so nothing in my life changes with the exception of how the accounts are titled. But now, if I experienced a time of disability, for example, so like Richard was saying earlier, that for some reason or another I can't manage my finances, then I could say, Paul, I need some help.
Oh, I'd love to help you.
Oh, thanks. So we can hold this together, which means that he can help me manage what's in here. Or it could go as far as, I can't manage it anymore, therefore, Paul, I trust you to manage that for my benefit.
Now, the beauty of this is that when either I'm invited to share the power and control with Danielle, or she fully hands it over, notice how every single asset still in the trust has maneuvered to me being able to manage it in one fell swoop with one easy transition, versus a power of attorney, which is usually what people utilize with a will. What our experience is, we have to go asset by asset, institution by institution to gain control and demonstrate that the power of attorney is effective. The other thing that we really appreciate is that now that I have control of the bowl, I have what's called fiduciary duties. All the instructions that you set up, Danielle, are in the document, right?
Yep.
So therefore, my fiduciary duty is to look at the document and follow her explicit instructions on how I utilize her candy for her benefit. In addition, I have a duty to invest. So I have to continue to keep her investments moving forward, versus a power of attorney doesn't do that.
Right.
I could just let it sit there and go down with the market, or I could leave everything in cash or whatever. I don't have that same fiduciary duty. So therefore, in a trust environment, it's actually more protective to Danielle to utilize this if she were alive, but needed that assistance.
I also get a lot of control in how we make that decision that I need assistance. And so, in a more traditional system, one or two doctors would say, yep, she's not quite thinking straight, but I shared with you at the beginning of this video that my parents live over in Tri-Cities, and they're probably the people who know me best. And so in that situation, their voices aren't heard. But in a trust environment, I can have control to say, I want their voices to be heard along with my doctors, to say, yep, she needs some help in managing her finances. Because they're the ones who would know, my parents would be the ones who would know, whether me trying to make a break for it out my front door in my nightgown is normal or not normal.
And we hope that's not normal.
We hope so, but you never know. But me being able to have that control does a couple of things, is that I do a lot of the settlements here in the office and the probates. And what we've seen is that if someone is in that situation where they're starting to need help, then it's really powerful to have people who they know and love and trust be the ones saying, yeah, you really do need some help, and they're willing to give it over rather than have it being taken. And so that's a really powerful thing, is to have that be a smoother transition into the disability process.
And so now we're kind of at the second part of a trust, well actually the third part of a trust. So the first part is you have full power and control during your lifetime. If there's ever a time when you experience the need for assistance, you are better protected and you have a greater voice in that process. And then number 3, at the time that we do pass away, because in our world it's not an if clause, it's a when. We hope it's extended, but it is when you pass away. Now, what do we do with everything else? Well, here's where we believe that this is a game changer. Now, I don't have 2 bowls. We actually do have 2 candy bowls in the office, but we're just going to use one. All right. I have my beneficiaries again, okay? But now, instead of doing this, here you go, in your hands, I hope you're responsible, and I hope nothing goes wrong. Now, give me back my stuff. Now, imagine that this bowl split into 2. And Danielle gets her part in a bowl, and Richard gets his in a bowl. Well, the reason that we want that is that we leave them what's called a trust share. They can have as much power and control over utilizing the assets, their inheritance, as you desire. So if you go, you know what, it's okay, Richard, you can buy a truck with big wheels. It's all right, you can go do that. Well then, Richard Trust would be, yes, go ahead. So now he reaches in, he pulls out a truck with big wheels. Now, let's continue the story, because I made you the downfall, right? Now that same accident occurs. He hits me, and I want to sue him. The beauty of having his assets that he hasn't spent in this bowl is that there is a shield of protection. When this is administered properly, there is a shield of protection that goes over this bowl, and it is the strongest shield known in law. Therefore, when somebody wants to come and attack Richard for that car accident, only his personal assets are on the table, because this is not under his name, his social security number. It is in and of itself. And so therefore, that car accident, they try to come and they try to take it, we can protect. Then his wife leaves him, but we've separated clearly the assets. She is not going to be able to come in and take a portion. Whether it was small or large, we don't know, but the whole point is that it's off the table now, and we have protected what remains. And you remember that bankruptcy he had to go through at the very end of his unfortunate story? Well, we have had our trust go through bankruptcy judges look at it, put it down and slide it back to the beneficiary saying, I can't use that. So it wipes out what he needs to wipe out without losing control and without losing his inheritance. In other words, it really empowers Richard this time. Stop being so bad. Now, what if he felt bad that he hit that person? Richard, could you use some of your finances to actually pay and assist the family that you hurt?
Right.
Yes, but the power is that he has control over it. And he doesn't have to have this taken from him. And for us, we believe that's a game changer. So I have 2 daughters, which means I'm a big sucker. And there is just no way that I would leave anything to my daughters outside of this protected entity. So, now we have a natural bend.
Mm-hmm. Yeah, we absolutely do.
So,
Like Paul was saying, we have a natural bend towards that this is something that is protective during your lifetime for disability and to protect your beneficiaries. And so it's a more flexible instrument than a will, and it allows us to do a lot more protections, and we're all, I think, around this table really interested in protecting the families and the clients that we have.
So the last part of our discussion here is we want to talk to you about what the 3-step strategy is. The 3-step strategy is that we have to develop your estate plan with counseling-oriented partners, commit yourself and your family to a formal maintenance program, which we're going to discuss, and then number 3, secure the back end. In other words, make sure that the transition is already set up and as smooth as possible. So how do we do that?
So like we discussed earlier, there's several different kinds of changes that plans can go through. There's personal and life changes that Richard discussed earlier, legal and tax changes, and then we're also always growing as attorneys. And so most of my clients would like me to be a better attorney this year than I was last year. So we want to make sure that our clients and their families get the benefits of us growing as attorneys and then making sure that the plans are continually updated with personal and legal changes as well.
Well, yeah, I'm sorry. What we found in the industry then is that most attorneys are document producers. In other words, I'll create a document and I'm going to slide that over to you. You're going to sign it and we're going to look at you and go, you're good to go. But our question is, well, good to go for how long? And because of all the changes Danielle just discussed, what happens is we build up an estate document. Let's assume that it's a very strong legal document. But over time, the uncontrollables, our family changes, our financial, the law, the taxes, our experience and how we deal with things, they begin to wear down the efficiency and the effectiveness. But what we've done when we're document producers is we've said, if you need us, you call us and let us know. But how does the average individual know when something in their life has changed to such a degree that they need to address it within the document itself? Instead of having that wear down, and by the way, approximately every 9 to 10 years, someone will redo their estate plan. So therefore, every 9 to 10 years, it's worn down and there's an uncomfortableness, so you come back to the office, if you can find the attorney, and they are going to recharge you because they're going to look at your document and go, oh gosh, your life has changed. Oh gosh, your finances have changed. The law has changed. Taxes have changed. So we got to throw the baby out with the bathwater and we got to start all over. And that's the kind of the dirty little secret of estate planning, is that making adjustments to a very old document is probably some of the worst things that you can do. Instead, we tend to say we have to start this whole process over. So our proposition is there a way to build this up? And now instead of it wearing down in efficiency and effectiveness, is there a way that we can fine-tune it so that it can always be ready? Here's the thing about estate planning. Danielle, I just need you to tell me, what day are you going to die?
Oh, great. Let's go get the calendar.
Yeah. Richard, do you have that date yet?
Nope.
Okay. I'm older than them and I still don't have the date. Okay. So if you can't tell me when you're going to die at least 60 days in advance, then we have to have a good estate plan. In other words, we don't know. I'm probably pretty grateful that I don't know. So if we use an older document that is not legally and tax sufficient, then we may be handing off a more difficult closing and something that may not exactly work as you've intended. Rather, if we can continue to fine tune so that there's never that dip, then we believe that that is going to be a stronger opportunity for your family to have as smooth of a closing and it meet your intent as possible.
So the way that we have, as a firm, created a solution to that is called our Legacy and Maintenance Program. And that is a formal updating program so that, like Paul said, you're not coming to us, but we as attorneys are coming to you. And so you are the experts in your life, so you're coming to us, letting us know what's changed in your life and your finances. We're coming to you with what's changed in the law and the taxes, and together we can continue to make sure that that estate plan is continually fine-tuned and we never have that big drop-off. And so our program, we have continuous legal and personal updates for you. Every 3 years, we reprint your trust and all of your powers of attorney so that they're always fresh and able to be used at any time, because we never know when we're going to need to. And we also make sure that your finances and that all the decisions that you've made in your trust, that you get to review those at least on an annual basis and make sure that nothing in your life has changed and that the appropriate people are still in your plan and where you want them to be. We also have guaranteed and fixed, so this is a yearly cost as well.
Right.
So there's 2 commitments to being in the program. One of them is the annual fee, and that is between about $600 generally. And then there's an annual meeting where we share with you your the legal and tax updates that have happened over the year. And so you're committing to also coming to those meetings as well. So in addition to educating you on what has happened over the year, we also offer educational sessions for those helpers that you've put into your plan. So who's going to close your estate and who is going to be who's going to manage everything if you're disabled. We also offer education sessions for them, because then we're not just handing them a red book and saying good luck. They actually have met us typically, and they're ready for when we need to use the document.
So our real proposition is that instead of just being document producers, we are actually proponents of having a relationship that doesn't stop with the document. The document is not a magic book. It doesn't just happen to work because you did the documents themselves. We need to train your family. We need to make fine-tune adjustments throughout our relationship together. As a matter of fact, about a third of our clients, you did the reviews of all the trusts this year as they came back in, and adjustments, and I don't know how many we did this year, but I think it equal to be about a third, like usual, that someone has some adjustments. Some of them would be minor, right? So what are some of the minor things that we saw?
Minor things, address changes, phone number changes, who to get in contact with. Some of the bigger changes might have been maybe a newborn grandchild.
And they were already leaving things to grandchildren, so we had to add that person into receiving a part of the estate and things like that. So all of these things need to be adjusted because life moves. And so we offer something what we believe is very unique, which is a relationship, not just documents. Well, I think we do documents really well. But at the end of the day, no matter how good we are, those documents will likewise begin the same process as every other document, which is they will wear down in their efficiency and effectiveness. And it's our passion to not let that happen. And likewise, it's our passion to train your family so that they are ready, because again, it's not an if clause, it's a when clause. So therefore, what we are doing is we are taking this opportunity. It's a crazy time right now, correct? And so during this month where we're required now to stay at home, where then we're going to be offering, instead of charging an initial price to get in contact with us, we are waiving that initial fee. We really want to be here to answer questions. We want to be here so that we can review things for clients. Now, a lot of this is going to happen by video, so if you have computers, which you do because you're watching this, then we're going to be doing a lot of video conferences, and so sharing documents. We have a secure portal so we can share things back and forth, and yet we can get eyes on things and meet each other one way or the other. So for this month, while we're kind of hunkered down as we move into April, for the month of April, if you reach out to us, the information is on the screen. You can call us, you can email us, just begin the communication. Let us know that you've watched this video and that you would like a personal counseling session. We'll get you on the calendar. Now, the meeting doesn't have to be in April. We just have to have your commitment to be on the calendar within April. And if you do that, then we will waive the initial counseling fee. We want to be a source of information, a source of peace in this troubled time. And so therefore, we're waiving this initial fee because we want to get to know you and get this step of estate planning moving in the right direction. So thank you so much for taking the time of watching this with, we hope it's been informative. We hope that you've already got a few things answered. Maybe the difference between a will and a trust, and at least put a little bit of curiosity so that you reach out to us. Call us at the phone number 425-939-9948. Email us and we'll get you set up with a video appointment at no cost. Thanks so much for watching. Hope you've enjoyed our session, Plan and Purpose.